We're going to take a look at what bailiffs can and cannot do in the hope that some of you learn something and really lose the fear, because that's what it's all about. It's about how they lie, intimidate and threaten. There's always exceptions to the rule, but I'm going to deal with council tax as a generality. I know you can't account for the unexpected, but this is for those who know how much they have to pay each year. If you don't set up a payment plan with the council by May, June, you can expect them to apply for a liability order. If you still do nothing, then you can expect, once a liability order is in place, that they will send it for enforcement. That could include an attachment of earnings order, or it could be bailiff. You should get a reminder for council tax. You should then get a summons before the liability order. Then you get the liability order, and the next thing you know will be a notice of enforcement from a bailiff company. To be honest, getting the bailiffs off your back for council tax is a lot harder than dealing with it in the first place. So setting up a payment plan is the preferred option. We know nobody's any money. We know everybody puts off the evil day. But it does cost you less, and it keeps bailiffs from your door. Right, let's move forward. You haven't paid your council tax, couldn't afford it, and now you've got a notice of enforcement through the door. What do? Well, you can ignore it. A warrant of control lasts for 12 months. Strictly speaking, bailiffs are supposed to return a warrant within 90 days. There has been much discussion recently about the number of times a bailiff can visit. Well, let me set the record straight. They can visit as many times as they want. What they can do, and do, is they charge you £75 for sending you a letter, the first notice of enforcement, and then they charge you £235 for a visit. They can't charge you any more unless they actually remove goods, and to be honest, that very rarely happens. So all in all, they're looking to make £310 out of you not being able to afford to pay your council tax. So the point about council tax is, can bailiffs force entry? Well, the answer to that is no. It may go through a side room in the magistrate's court, but it's still a civil debt, and bailiffs have absolutely no right to force entry no matter what they tell you. You may get a notice saying that they're going to attend with locksmiths, etc. It's rubbish, and you need to lose the fear about this and realise that the best they can do is knock on your door. The only way they can come into your house is if you let them. A word of warning, as with all warrants of control, if you've got a car, it's vulnerable. I'm going to deal with that a bit later on. My own view is, if you've got bailiff's brain at your door for council tax, don't answer it. Make a cup of tea, watch the television, do what you want, just don't engage with them. Some bailiff companies have taken to texting people, and the natural reaction for anybody is, if they get a notice through or a text, is to make contact with that bailiff. That's mistake number one. They want to frighten you, they want to intimidate you, and they want to threaten you. So if you don't respond, you don't give them the opportunity. Okay, I'm talking about council parking tickets here, not those that you get in a private car park. You get a parking ticket, 14 days later you get a notice to say you owe more money, and then after that you get what is called an order for recovery. The parking tickets then pass to the bailiffs with a warrant of control issued from Northampton Traffic Enforcement Centre. Again, the bailiffs will add £75 for sending you a notice of enforcement, and a further £235 if they pay you. There are a number of ways in which to deal with a parking ticket. You may not have even known about it. Really, you need to complete forms TE7 and TE9 and get those emailed off to tech. That will take it back to the council where they can review the situation. Equally, if you have made representations or you've appealed a parking ticket and not heard back from the council, then TE7 and TE9 should also be used. When it comes to bailiffs enforcing for a parking ticket, as with council tax, they have absolutely no right to force entry whatsoever. However, one advantage they do have is that they generally have the registration number of the vehicle, so that is more susceptible to clamping than any other type of enforcement, simply because they have already been able to identify the vehicle involved. So again, if you do get bailiffs at your door for a parking fine, don't open it, don't answer, don't engage. As with all civil debt, keep your doors locked, don't let them in, you don't have to. Okay, the next one we're going to look at are county court judgments. Now again, there can be problems with these and you may not even know you've got one. So I want you to listen carefully. If you don't know that you've got a judgment against you and you get notice of enforcement, then there are steps you need to take swiftly to apply to have the judgment set aside, if that's a possibility. That's using form N244 and an EX160 if you're entitled to a remission. Now, if somebody has obtained a judgment against you through the county court, probably through Northampton, then it's a civil debt. It's not criminal, it's civil. Once a judgment's obtained, if it's more than £600, it can be transferred up to the High Court for enforcement. But in respect of civil debt, High Court enforcement have no more authority than a certified bailiff. They have absolutely no right to force entry. It's just the same as council tax and parking tickets. They can knock on your door, they can threaten you, they can intimidate you, but they cannot force entry. So, court fines. It's a bit more serious and we have to look at different aspects. If you've been fined by the magistrates court, whether it be for TV licence or indeed anything else, then you need to take heed of what can and cannot happen. Fine, usually because they've moved address and the proceedings have been sent to a previous address. If you do get a notice of enforcement for a magistrates court fine that you know nothing about, hot foot it to the magistrates and do a statutory declaration. This will take it back to the time before the hearing and you've got the opportunity of defending and rectifying a wrong. Don't mess about, don't leave it, don't delay, just do it. Now there are two things about this. Firstly, any fine imposed is likely to be higher if made in your absence rather than if you were in attendance at court. And secondly, no enforcement proceedings can take place while a statutory declaration is being dealt with. Now, for anybody that has been fined by the magistrates, you will be sent a notice of fine and collection explaining details of what is required for repayment of the fine. If you fail to pay then, you will then receive a further steps notice being your final warning before enforcement action will be taken against you. So at that point you've got 14 days and 14 days only in which to set up a payment plan. Immediately after that, it will be sent to the bailiffs for enforcement. Now, the next thing is means testing. Everybody should be means tested as to their fine and their ability to repay a fine. If this hasn't happened, this is another reason for it to go back to the magistrates to be reassessed. One thing I would say though is if you have agreed a payment plan with the magistrates, do not be late in making that payment, even by 1 day. Failure to keep to a payment plan will result in your fine being sent immediately to bailiffs. No second chance, no delays, no messing. It's done automatically these days and you need to understand that. So if you find yourself facing a situation where you are expecting bailiffs for non-payment of a magistrate's court fine, you need to prepare yourself and be aware of what the bailiffs can and cannot do. Now, the most important thing is they can force entry. Now, by forced entry, I mean they can instruct a locksmith, and that is it. So I would suggest to anybody that they get internal bolts to their doors so that any attempt at forcing entry would be unsuccessful. Now, one of the major problems with this is that when a bailiff knows he has a right to force entry, there is the temptation to call the police and obtain what they believe to be assistance. One thing I will say, and that's that bailiffs are known to call for assistance for civil matters rather than criminal matters, and that's even worse because the police hear the word warrant and automatically think that it's criminal. Well, the fact remains that a warrant of control can be either criminal or civil, and it's important that everybody understands the difference. Criminal warrant provide for forced entry. We are constantly having to educate the police on the rights and wrongs of bailiffs and of Section 26. It shouldn't be necessary, but it is. Now, Section 26 is there to prevent misuse of powers by police constables, particularly if it is for the benefit or detriment of himself or another. The misunderstanding of the police is quite scary, really, when it comes to forced entry and the fact that they believe that they can actually, in some circumstances, use the red key to assist bailiffs. Or the police will attempt to coerce a debtor into opening the door by making threats. The clamping of vehicles is probably the most controversial thing we deal with. There are many arguments about the rights and wrongs of it, but at the end of the day, if there's a warrant of control, there's a risk your vehicle will be clamped. Bailiffs should do a HPI check to see whether or not there is any finance on a vehicle before it's clamped. So if it is on finance, that shouldn't happen. Now, the registered keeper, come owner problem, raises its head time and again. If the car is registered in your name and the insurance is also registered in your name, it's going to be very difficult to prove that the vehicle is owned by someone else. Now, what you've got to remember is that bailiffs don't actually want to remove your car, they actually want you to pay the debt. So they do use this as blackmail because it causes unsurmountable problems for people whose vehicles have been clamped. It's also the situation where a debtor is likely to become more agitated, and that gives the bailiffs every opportunity to call the police for a breach of the peace, and in the hope that the police will then assist. Now, if bailiff has clamped your car, it's an absolute bugger to get it unclamped. Bailiffs are reluctant to do it, and they know they can use it as leverage. So the best thing is try and avoid it if you can. In the unfortunate event that bailiffs do get into your house, you need to know your rights in respect of what they can and cannot take. The first thing they'll do is they'll go around your house and try and list as many items as they can. Now, it's important to remember what they can and cannot list and where they shouldn't go. The other thing is that they should only list items that belong to the debtor. The most vulnerable items in your house are your televisions. Most people don't have sufficient goods to cover a warrant because it also has to include the fees and removal costs as well, which have to be added to the debt. Unfortunately, that doesn't stop bailiffs listing anything and everything they think they can. So they've made a list of goods they want to take control of. The problem they have is that you don't have to sign it. So if you refuse, that's it. There's not a lot they can do, and there's no controlled goods agreement in place. At this point, they know they're stuck. You haven't got sufficient things for them to remove them from your house. Don't forget, it's your money they want, not your goods. At the end of the day, if they walk away with nothing, they get nothing, they don't get paid, and they will have to return the warrant to their client. I've not mentioned vulnerable debtors so far, but it does apply to anybody who has an outstanding warrant of control, irrespective of whether or not it's civil or criminal. I see much about vulnerable households, but I have my own view, and that is that it is the debtor that needs to be vulnerable rather than a member of the household for it to be applicable. If anybody is vulnerable, then they must do the vulnerable letters to the creditor and the bailiff company as soon as possible. As soon as they receive it, and you can send it by email, they must look at it. Now, you need to be aware that there are two problems which currently exist. The first one being that a creditor will say, well, it's in the hands of the bailiffs and we can't take the warrant back. That's rubbish. The second problem is quite simple. The bailiffs have got wise to the vulnerable debtor situation, and rather than returning a warrant to their client, they are hanging on to it and trying to negotiate payment plans at reduced levels and taking the time about doing so to make a debtor feel more comfortable. But the fact remains, at the end of the day, they should return it. One of the major problems with the vulnerable debtor letter is that there's insufficient information for anybody to accurately make a decision. You must put as much information in as possible, giving details of illnesses, medication, hospitals, consultants, anything, so that you can explain your situation so there is no doubt when your letter is received that they understand that you are vulnerable. If you do the vulnerable letter correctly, then your account should be sent back to the original creditor without the bailiff fees attached to it, whereupon you can then negotiate a payment plan. Don't leave it and do nothing, otherwise you'll finish up back at square one with bailiffs at your door. Right, well, that's an overview. It's not as in-depth as I'd like, but I didn't want to bore you all forever and ever. I'll do separate videos for each thing in more detail, so that if you want to listen about one particular aspect, then you can. And I just want to say thanks for listening. Keep up the good work, everybody. Listen, learn, and lose the fear. Cheers, guys.